Hi, so thank you everyone for joining this webinar today. We're going to be discussing key considerations when buying a business. So before we begin, I just wanted to go through a couple of housekeeping things. So you'll be emailed a copy of this webinar recording afterwards. If you have any questions when we're speaking, please put them in the chat box that you can see on your screen. And after the webinar, we'll be emailing a survey around, so please feel free to fill this in. So my name's Sarah Aldersley. I'm a practice leader in the corporate team here at Legal Vision, and I have Matt with me as well.
Hi there, I'm Matt, and I'm a senior lawyer in the corporate team at Legal Vision.
So today we're going to be speaking to you about a variety of different things to do with selling a business, buying a business. So firstly, the different sale types that you can encounter when buying a business, various assets that are used in businesses, due diligence, transferring assets, contracts and liabilities across from a seller to a buyer, conditions precedent that you will want to include to make sure that these happen before your sale completes, transferring employees, restraint of trade, a little bit on GST, and then also make sure you stick around because at the end we'll have a Q&A session and we'll also be giving details about a special offer. So to begin with, differences between an asset sale, a business sale, and a share sale. So you might hear these terms being thrown about, and what do they actually mean? So if there's an asset sale, really this just means that you are buying specific assets of a business. So in an example where Harry owns a rental car business, it's owned by Harry Smith Pty Limited, trading as Harry's Cars. If there was an asset sale, it would just be the case that he's selling, say, half of his fleet to another rental company. So he's not selling his whole business, he's just selling certain assets of the business. Where there's a business sale, it's the same as an asset sale in the sense that it's just assets being sold and liabilities as well, which we'll get to, but it's everything that you need to run the business. So in that scenario, it wouldn't just be kind of half of the fleet, it would be all of the cars and everything else that Harry needs to run his rental business. When there's a share sale, it's slightly different. So rather than buying individual assets, you're buying shares in a company. So once you bought those shares, you will actually just own the entity that's trading. So you get everything, every asset it has and every liability as well. So here that would be Harry is the sole owner of the business, selling his shares in the company to the buyer. And in this presentation, we're going to focus on a business sale. So I'll hand over to Matt now to discuss the steps that are normally required.
So it's always good to get a picture of the sale process. Certainly the sale process can change depending on the specific sale at hand, but here we have an outline of a map that goes through some of the key steps. And so it's always good to be discussing some of the key commercial terms off the bat. So that includes things around the purchase price, whether that's all being paid up front. As well, it's probably useful to talk about some terms that we'll use during this webinar. Some of them are signing, so that's signing of the sale of business agreement or heads of agreement, and we'll clarify. And the other relevant term is completion. So that talks about when the business is actually handed over, you as the buyer pay the purchase price, and then that's also what's also referred to as settlement. So completion and settlement are kind of interchangeable terms. And so looking through this process here, we have key terms being agreed early on. You can have a heads of agreement being put together. This is a document that outlines some of the key commercial terms and isn't as long as a formal sale of business agreement. Next, once that's signed, sometimes there's things that happen in between the heads of agreement and the sale of business agreement, and that can include due diligence, or that can happen after the sale of business agreement, and we'll get into more on that a bit later. So once the sale of business agreement is signed, that's when the deposit is paid. And then after that, you can have things between signing and completion that need to happen. And Sarah will touch on this later. These are known as conditions precedent, but include things like the transfer of the lease or signing a new lease, or other things that need to happen. So the next slide. Yeah. And so when you're buying a business, it's always helpful to think about what you're actually buying, whether that's a cafe, a manufacturing business, a purely online business. it's helpful to think about what the assets you're actually buying. So here we've got a couple examples of things that are included. And so we can be buying owned or leased equipment. So owned is obviously that the seller owns these outright. Leased equipment are things that they're obviously leasing. And so that can complicate how they're dealt with, because some other third party is the actual owner of that leased equipment. So you need to have discussions with them. With intellectual property, obviously this can be key to the business. And so things like trademarks, other branding that aren't trademarked, content on a website, other kind of know-how is what we would define as intellectual property. So typically in a business sale, meaning all of the assets of a business, you'd be getting all of the intellectual property, and would also include things like the business name. Important contracts. So clearly for a lot of businesses, there can be important contracts, whether that's with suppliers, with clients, and you want to make sure that these are in place and that they're fit for purpose. And so we can get into that a bit later as well. Stock, that's referring to something like a cafe where there is coffee beans or pastries, or the supplies for making food at the premises. And then we have employees. So clearly for some businesses, the actual employees that are engaged by the seller can be key to the operation of the business. And so we'll need to think about whether you want to keep them going forward, which we'll talk about a bit later as well, which is very important, is the licenses that you need to operate the business. So with some businesses, there are specific regimes and licenses that you need to comply with and have in order to run that business. And so that will cater to the specific business at hand and is a bit more of a technical point. Now, we had a couple questions already on due diligence, and it's a very important and topical stage of the sale process. And so with due diligence, the term gets thrown out a lot, but really what it is you investigating the business. And so you're having a chat with the seller, they're saying you're buying such and such business, and you want to make sure that you are getting exactly what they're saying you're getting. So this is what's referred to as due diligence. And really there's a couple different types. There is legal due diligence. So that's looking at the contracts and other documents that are in place, or it can be researching the IP, so trademarks, and making sure they're validly registered. You can also have financial due diligence, so making sure that the earnings of the business are being looked at by an accountant to confirm that the seller's accountant has accredited profits and losses correctly. I mean, you can also have commercial due diligence to make sure things like the earnings of the business on a less technical scale are what they say they are. And as well, in terms of the timing, due diligence can happen at a couple different stages, as I referenced earlier. So as a buyer, you want the due diligence to happen as soon as possible. And so that can be before a heads of agreement is signed, or after a heads of agreement is signed. It can also happen once the sale of business agreement is signed, so it's a little bit confusing there. We can go back and touch on that, but really as the buyer, you want to make sure early on in the piece that you know what you're getting, whereas the seller wants to lock in the deal, and so they also will have confidential information that you're looking at as part of due diligence. So typically they'll want some sort of at least confidentiality obligations put to you as the buyer before they're giving you specific, documents that set out how the business is operated, because that can give you a specific information that if the sale didn't go ahead, you might be able to use otherwise. So it's important to think about when that should happen, and it can happen at a couple of different stages. But as the buyer, yeah, you want it to happen early on as possible.
Yeah, thanks, Matt. So you've done your DD, you sort of know what assets are in the business that you're buying. And the next step is to actually think about transferring those over to you. So the general rule is not to assume that those assets and contracts will automatically transfer. When you're doing your DD, you should be looking at things like contracts. Sorry, I just lost my slide there for some reason. never mind, I'll just freestyle. So you can look at things like contracts. Do they actually need any counterparty consent to transfer those? Things like a lease, you generally need the consent of the landlord. So you'll be looking at those sort of things when you're working out how you actually do the transfer. So normally there'll be an assignment clause in an agreement. So if it says that you can't assign without consent, you know that to transfer it across to a buyer, you need to reach out and get the consent of the counterparty. For really, really key contracts in the business, you often don't want to rely on just kind of sending a notice out saying, we've bought the business, we're the new buyer, here are our bank accounts, details, kind of we're going from there. You actually want to make sure that they've consented to it. And that's what's called a novation. So you actually have the seller, the buyer, and the counterparty signing up to a deed of novation where you all agree that the contract's going to transfer and the buyer's going to take it forward. So we don't recommend that you do those for every contract at all. That can often be overkill. You know, a lot of contracts that businesses have are just really standard form. All you need to do is sort of notify that the business has changed hands and you're good to go. But for the really, really key ones, we do recommend that that's put in place. And that's always a good way of, you know, starting the process of getting that counterparty consent as well, as part of getting the deed of novation signed. So if you've got any leased or financed equipment, how those assets will transfer across will be a little bit more complicated because you will have to either sort of pay out the financing on that equipment before it can be transferred, or get the consent of the lessor of the equipment to transfer it alongside the rental payments that will be continuing. Same with the lease, or if the business is a franchise, if there's a lease in the property, you always have to get landlord consent to assign. You can't just transfer that without that. And the same with the franchise. So you'll have to reach out to the franchisor, say you're buying the business, negotiate with them, getting that franchise agreement transferred across to you. And then another key thing is to make sure that all the assets that you have aren't encumbered. So we can carry out what's called a PPSR search to let you know if there are any security interests over assets. And if there are, you'll want to make sure that these are released before they're transferred to you, because otherwise there'll be what's called encumbered assets when you're taking them over, which you don't want. So as well as assets, businesses will have liabilities. So these are things like if there's a lease, the obligation to continue paying the rent. If there's a contract that's only been partly performed, then the obligation to carry on performing that contract. So again, in the same way as the assets, generally, you can't just assume that you're getting them. They're not transferred until it's been agreed. So this is particularly important because obviously as the buyer of a business, you want to take on as little liabilities as possible. So liabilities such as employee entitlements, generally you take these on. So if you're employing employees going forward, they have accrued entitlements to things like annual leave and personal leave. Generally, the buyer will recognise these. The seller will pay a contribution, and Matt will talk about this in a little bit. But you'll set out in your agreement kind of what's happening with those entitlements. You don't automatically take them on. Same with things like the work in progress liabilities and any other ongoing contractual arrangements. You'll have to agree with the seller what's happening with them, when you're taking them on from, and what those look like. So conditions precedent. So these are things that you want to happen before you're happy for the deal to go ahead. Most business sales will involve at least one of these. So it's things like if there is a lease and you want to make sure that you're taking it over, getting the landlord consent you'd put as a condition, because you don't want to go ahead and complete and buy the business and actually that lease is left behind because the landlord hasn't consented yet. Same with if it's a franchise, you know, you need that franchise agreement to run the business, so you need to make sure that the franchisor has consented before you do the deal. Transferring key contracts. So as I said before, you know, lots of contracts are just standard form. You don't need to worry too much about them. But if there are any that are really, really key, so it's like a huge supplier contract or really big customer contract that you don't want to take the business over if it doesn't come with you, then you'd make it a condition to completion that that counterparty has consented and that contract is being transferred. Again, key employees. So if you are not prepared to run the business without certain employees being employed, then you'd make it a condition of the sale that those people have agreed to come across. And regulatory consent. So if it's a business where there's any sort of licenses that you need to run it, then you obviously can't run it without those. You need to make sure they're in place before you take the business over.
And so transferring employees is obviously another key part, as I kind of mentioned earlier, and it can lead as well, like Sarah was saying, this can be a condition precedent. But at a high level, there's really two options as to how employees are dealt with. Either you as the buyer say you don't want any of the employees, and in that case, the seller has to deal with those employees, including terminating and paying out any employee entitlements, or that you say you do want some of these employees and you provide them with offers of employment, and whether they then accept or not will determine whether you're taking them on. And where you do take them on, there is certain obligations to recognize prior service. Generally, this looks at things like annual leave, personal leave, so sick leave and long service leave. And so because you're taking these entitlements on, as in you'll owe them to the employee after the sale completes, there is an adjustment to the purchase price to reduce it. So just to go over that again, you're taking on one employee, they've got a certain number of sick days, and so because you're going to recognize that going forward, there's going to be a reduction to the purchase price in accordance with a certain percentage of their accrued sick leave. So the actual percentages that it's adjusted by can vary, but really the key ones to think about as the buyer is things like long service leave and personal leave, because these are ones that you would need to recognize. Annual leave can be, you can say that you're not going to recognize it, but that's really a practical point that, you know, when you're taking over a business, generally employees, if they have 2 weeks annual leave, will want to use that in the future. And so it might not create a great situation where that's actually going to have to be paid out and then they start afresh, especially now that we can travel. So something to keep in mind. But generally, these are things that are discussed early on in the piece. You as the buyer, it's probably helpful to have a chat with a lawyer first before you go and agree to what will be done with the employee entitlements. And as well, if there is certain key employees, you may want to say that completion of the sale is conditional on them accepting an offer of employment with you. So how that looks is you sign the sale of business agreement. The sale of business agreement says that X manager needs to sign a employment agreement with you prior to the sale completing. And so in between signing the sale of business agreement and actually completing the sale, you and the seller are working together to get that person to sign. And only if that person signs, then can you be forced to proceed with the sale, pay the purchase price, etc. But as an overview as well, both options involve the termination of employees. So it's referred to as transferring, where they come across to the buyer, but there's still a termination by the seller and an offer by you, the buyer, and then there's an adjustment as to the employee entitlements. And under the Fair Work Act, you're required to recognize some of those entitlements. And yeah. And so a very important part is a restraint of trade. This is a concept that goes into the sale of business agreement. And so you as the buyer want to know that the seller isn't going to set up a competing business after the sale completes. So where this is a premises-based business, being, you know, you have a bricks and mortar location, these restraint of trades are expressed over a period of time and within a certain distance. So say, for example, 20 kilometers in 2 years, and it covers a number of activities that the seller is prohibited from doing within that time frame and distance. So these can include them not setting up a competing business that's the same or similar to. There's fairly standard wording that goes into some of these, but the essence is that they can't set up a competing business. It also goes to them not taking over customers or clients or interfering with them. And as well, another key part is them trying to take or poach employees that were engaged by them as the seller, because they would have the rapport with those employees. So you want to make sure that, you know, in the contract, the sale of business agreement, they're prohibited from doing those actions. It's a fairly technical legal point when looked at by a court, restraint of trades, because they're only enforceable. So if there's a breach of one and you need to go to court, they're only enforceable to the extent that they're reasonable. And so when a court is determining whether one is reasonable, they'll look at things like the purchase price, whether it's necessary to protect your interests as the buyer, and the bargaining powers of the parties, etc. And so they're only really enforceable to the extent they're reasonable, and so they're expressed in a specific way to cover that off. But certainly it's important you have this discussion with your solicitor and make sure that you're going to be protected, even where it's an online business. Then it might just apply to Australia in total, and so it's a key thing to have a discussion about. Another key point here is around GST. So typically, because we're referring to a business sale, so a business sale, as we're referring to it here, means all of the assets of a business. And so when you buy a business and you buy all of the assets necessary for the operation of that business, it's generally referred to as the sale of a going concern. And so when it's the sale of a going concern, there is no GST paid on top of the purchase price. The inverse of that is that where you're only buying specific assets or a piece of a business or a branch, then you would have GST payable on top of that purchase price. So this is an accounting point, a question that you can raise with your accountant, and they can guide you as to whether they determine it would be the sale of a going concern or whether GST should be paid on top. As well, another key point is the apportionment of the purchase price. This is probably, this is another one you can have a chat with your accountant about, but generally when you're buying a business, it's apportioned, meaning split between goodwill and plant and equipment, and sometimes other things as well, like stock. And so what this means is generally you as the buyer want to depreciate some of the assets of the business. So you want to try and have an argument that there should be a higher amount put to the plant and equipment, so you can get a tax benefit of depreciating that. But this is just something to raise with your accountant, because it can't just be that you're looking to get as high of amount as possible for plant and equipment without any real backup or evidence as to why it should be that. So a couple points to have a chat with your accountant about. And as well, we have a guide that's been fairly recently released, and so it's called How to Finance Your Business Purchase, so talking about vendor finance and other issues. So you can actually download this now in the called handout section of your web panel. Basically on the side there, you should have a panel and you can actually download this this guide, have a look through it, and let us know if you have any questions.
Right, so onto the Q&A. So we've had quite a few questions coming in. So I'll just pick one and go ahead. So someone's asked, for a business sale, can you exclude certain parts of the business, e.g. liabilities that you don't want? So yes, you can. This is often why people choose to go down the business sale route rather than the share sale route, because they can more easily pick and choose what you're getting. Obviously with a share sale, you're getting everything. With a business sale, you can negotiate what comes across. The only caveat here is, as Matt's just touched on, if you're excluding enough of the business that you're not actually taking it on as a going concern, then you'll have to pay GST on the transfer. So you want to make sure that you are actually still buying a business, even if it's negotiated where a couple of things aren't coming across.
Yeah, I can do the next one. There is about, someone's asked about a deposit, and so whether this needs to be paid, specifically relating to conducting due diligence. So I mean, you as the buyer, we to be honest, we don't really care whether a deposit's paid or not. The deposit is really a security for the seller. In most larger sales, there will be a deposit paid, and so that's just something to bear in mind. But certainly, you could propose that no deposit's paid. But really, the key protection for the seller there as well is, one, the deposit makes sure that you're got your foot in the door and you're willing to go ahead. And then as well, around due diligence, the key part there is that the sale of business agreement talks about your confidentiality obligations, and if it's terminated, then that you have to return and destroy certain information. So two kind of pieces there.
Yeah, I'll take the next one. So what are the chances of the existing business to conceal liabilities, and what are the methods to uncover the same? So this is where DD is really key. So obviously you're trying to find out what the business is made up of in terms of assets and liabilities. If you're conscious that you're worried that they're kind of concealing anything from you, then that's where, you know, getting third-party advisors in to help you with the process is really key. So especially, you know, financial advisors and accountants, they can trawl through the accounts, you know, try and verify the underlying value of the things that they've put in their accounts. Same with legal DD, you know, we can go through contracts and flag whether there may be any risk and liabilities to you. Other things like, you know, site visits are really helpful. If it's a business that's got a lot of stock and equipment, if you actually do a site visit, you can quite easily and quickly see, you know, is the level actually anywhere near what you're expecting it to be? Is it in the right shape? Is it what you're expecting? So yeah, DD is really key, but on top of that, what you can then do to protect yourself is put warranties and some indemnities in your sale agreement. So obviously it's not ideal to buy a business and then have to bring a claim, but at least it is there to protect you in the instance where, you know, something has slipped under the radar, you weren't aware of it, you've completed, you paid a certain amount of money on the basis the business is worth X and actually it ends up being worth Y. At least you can then have a claim, you know, there's breach of warranty here, or you haven't disclosed something to me. So that's kind of the two different limbs of how you'd protect yourself.
Yeah, and I'll take another one here on employees. I'll try and cover off 4 questions with 1 answer. And so it's really about employee entitlements, whether they should be paid out before completion, and whether we require termination or reemployment. And then as well, we can go into if employees have been paid illegally, but whether they can be paid out before settlement. There's specific entitlements that are never that aren't paid out where there's a transfer, and you as the buyer are, you know, you have an obligation under the Fair Work Act to recognize what's called the prior service that employee. So this specifically relates to long service leave and personal leave, so sick leave. And so the seller can try and pay them out, but technically it's still an obligation on you as the buyer to recognize this going forward. And so really it changes a bit on the states as well, but really the easiest approach is that there is a reduction of the purchase price. You as the buyer take on these entitlements, and away you go, and that you recognize them going forward, because you can try and get around it, but really for some of them, long service leave and personal leave, you still have an obligation to recognize them. And the next point, can you require termination and reemployment? At completion of the business sale, there's always the termination of the employees by the seller and the reemployment by you as the buyer. So there's always that termination on or around completion of the business sale, so when it's actually handed over. And the other one around illegally being paid, yeah, that's certainly a risk. And so as Sarah was talking about before, there's certain protections you can put in the sale of business agreement. These are called warranties. Warranties are promises that the seller makes about the business. And so that can say that all of the employees have been paid in accordance with their award and that they've been paid all due employee entitlements. Now, to protect this as well, one thing we didn't go over is whether you want a personal guarantee in the sale of business agreement. So if the seller owns the business through a company and you have a sale of business agreement between your company and their selling company, you can only bring a claim against their selling company. And if the only thing that their selling company owns is the business, then after the sale is completed, there's nothing really to bring a claim against. So some protection can be to have a guarantor sign, meaning that one of the directors signs personally and that they're on the hook for those warranties, so promises about the seller's business. This is a point that's pushed back and forth. The seller doesn't want to provide a guarantee. You as the buyer want one. Usually, you know, both sides in larger sales end up providing a guarantee to some extent, but not always over all of the terms of the sale of business agreement. So it can be a bit technical there.
Yeah, and actually just picking up on something that Matt just said around someone asked a question about what if you find out that they've been underpaying employees before you take over the business. Warranties only get you so far. So to the extent that you actually know something is wrong, you can't then bring a warranty claim because it's normally qualified by buyer's awareness. If you knew that that was a problem and you were still going ahead and still paying that same purchase price, and sort of you can't really then claim. So what you'd have there is an indemnity. So this is where you know there's a problem. So for example, you think that there's an issue about underpayment, you're worried it hasn't been sorted out properly, you'd ask the seller to provide an indemnity. So to the extent any employee then claimed against you when you're taking over the business, you can then claim against the seller under that indemnity on a dollar for dollar basis. So again, this is where DD really comes in and is really important, because if there is something that you find out about, either you can ask for a purchase price adjustment, or you can ask for an indemnity, so that later down the line you kind of know that you're covered and you can go against the seller, which ties in nicely with the guarantee point. You want to make sure there is someone there kind of standing behind that indemnity. So another question that we've been asked is how to acquire shares when buying a business. So the first step here really is to ascertain who the shareholders are. You don't want to be in a position where you think you bought the whole company and it turns out actually one of the shareholders hasn't sold to you. So you'd ask for a register of members, of which the company should be maintaining. You check this against asset records as well, just to make sure that you are aware who owns which shares. And then you'd have a sale agreement which sets out kind of the key commercial terms of the sale that everyone would sign. But in terms of the actual legal document which transfers ownership of the shares, it's called a stock transfer agreement. It's a really short 2-page agreement. It sets out who the company is, what the shares are, how many class of shares, so things like their ordinary shares, seller, buyer, purchase price, and then if the buyer is going to hold those shares beneficially or non-beneficially. So if you're holding as a trust, then it would be non-beneficially. So it just has those really key points that you'll pull from your longer form sale agreement, and then you'd buyer and seller would sign that, and that's then the legal document that's transferred those shares.
Yeah, I was going to say there's a couple of questions as well on valuing a business. So luckily for us, or unluckily for the people wanting the answer, this isn't something that we as lawyers provide. Valuing a business, there's specific people that deal with valuations. As well, business brokers can assist with confirming valuations, and there's certain tools online that you can look at. The traditional way is that you engage a business valuer, and they conduct a formal business valuation. That can be quite costly, so some different approaches is a specific business valuer, speaking to an accountant or tax advisor that's familiar with business valuations, as well business brokers. So there's a couple different options there as well. Someone else has asked for some of the pitfalls or sources of disagreement between the buyer and seller. Just generally speaking, I think one thing is trying to set timelines that are too tight. Oftentimes, because there's many moving parts, if other people involved, including a landlord or franchisor or someone owns, there's leased equipment, oftentimes parties have this expectation of things moving very quickly, and when that doesn't happen, that creates stress on both sides. So I think having a chat with your lawyers and figuring out what a realistic timeline is, allowing a bit of time for slight delays, because otherwise everyone has this expectation it's not being met. It adds a decent amount of stress. I think as well, another key point that lends to that, or things to do, is to try and get lawyers involved early on in the piece, because sometimes when buyer and seller meet together, they think they've hashed out the whole deal, and then when it comes time to a sale of business agreement, it can be a fairly long document that covers issues that might not have thought of, and so there can be some friction because of the difference between where this buyer and seller thought they were in terms of negotiations and everything being agreed, and where it actually is. So I think having the lawyers involved earlier can be a good thing.
Yeah, so we'll just do a couple more. Someone's asked if a company has a substantial amount of accumulated tax losses and is planning on either selling the business itself or selling all the shares, given tax losses can be beneficial, does it have any impact on the sale price? So here, if you're doing a business sale, you won't necessarily get the benefit of those tax losses because they stay with the entity that they have been accumulated by. If you're doing a share sale, you are taking over the business with those tax losses, then yes, if you often negotiate on the basis of the business is kind of cash-free and debt-free. So you agree a purchase price and say, the extent there's actually any additional cash that you're getting, you'll pay more. If there's debt, you'll pay less. So the tax losses can be something that goes in that negotiation. So if you can treat them as a cash-like item, then you would pay more for the purchase price. But again, it's a negotiation with the seller as to kind of what you're both comfortable to do there. And then another one, if it's a share sale, would employees automatically transfer to the new buyer? So yeah, because there's no transfer happening there. If it's a share sale, then your employees remain employed by the same entity pre and post completion. The only thing that's changing is the entity that owns that company.
Yeah.
I think we've covered most of them now.
There's one on due diligence and key customer contracts. I think for, there can be a lot of terms in a contract with a customer. I think you as the buyer want to think about, are these clients that are locked in, and so they're on some sort of subscription or membership base, in which case you want to make sure that it's drafted appropriately to try and kind of lock them in and have certain mechanisms for termination. And so, it's certainly good to have a lawyer have a look at it, because there's rules around unfair contracts that can apply. There's Australian consumer law as well that can apply to these, where these are standard form contracts with customers. But really, I think, it's not about kind of throwing around a couple terms, but really about having, if those are integral to the business, or it's a subscription or membership based business, having a lawyer look over those, and making sure that they're not caught by some type of regime that would make them unenforceable is probably the most important part there.
Yeah, depending on how you're buying the business, if it's a business sale or a share sale, we'd also look at how those contracts can be transferred if they need to be. If it's a share sale, no transfer happens, you're just buying the entity. But a lot of contracts have what's called a change of control clause in them. So even though they're staying with the same entity, if the person that controls the entity is changing, you have to get counterparty consent. So we'd also look at the contracts for that to make sure that you have got all the consents in place that you need for that to actually come across to you. Another one that's come in is the deposit refundable if they don't proceed with the purchase? So it depends what you set out in your heads of agreement, really. But often you will, if the seller pulls out and the buyer has done anything wrong, the seller just changed their mind, then you would get your deposit back. If the deal's fallen through because something the buyer's done or the buyer's pulled out for kind of no good reason, then that would be often kept with the seller. So yeah, you can negotiate, but obviously it's kind of common sense approach. You want to make sure that you get your deposit back if it's not your fault.
Yeah, and I was going to say, generally, one of the reasons why a deposit would be refunded is because one of those conditions precedent can't occur, like the landlord refuses you as a tenant. So under that scenario, if it was a brick and mortar business, then obviously you wouldn't want to proceed, and under the agreement you shouldn't be forced to proceed. And so there, it's neither the seller or buyer's fault, and so typically the deposit would be refunded in that situation.
Yeah, and then I think final one that we've got time for is how long does it usually take for the whole selling process? So it really depends in terms of kind of how big the business is, what assets it does have, if you're doing a share sale or a business sale. Because if you're doing a share sale, then you need to be normally a bit more thorough with your DD, because you need to make sure that everything, you know about everything that's in the business, because you're getting the whole company. So it depends on that. It depends on kind of how bespoke the terms are that you're negotiating and how much negotiation is going to be happening around the sale agreement. But I mean, general rule, a quick sale would be a matter of weeks. A really quick sale, but it can happen, but generally both parties need to be fully on board. Like, this is happening, we're giving you all the information you're asking for on time, and we're not going to be silly with our negotiations. On the other end of the spectrum, they can take months and months and months. So yeah, it kind of depends who you're buying from, how happy they are with the commercial terms and things like that. So that's probably the end of Q&A session. So we just wanted to briefly touch on how we work here at Legal Vision and what we can offer you. So We work on a membership basis with our clients, so it's called LVConnect Pro, is a membership product. What this gives you is basically all your day-to-day legal assistance that your business will need at a fixed price that is affordable. So it includes things like unlimited document drafting and reviews. So if you did need any kind of employment agreements drawn up, or if you wanted us to look at any customer contracts, then we would do that within the membership. Also includes unlimited legal advice consultations. So particularly when you're buying a business, you know, you're coming in to a new business completely fresh. There'll be lots of things that you're uncovering. You might have quite a few legal questions along the way. You can just pick up the phone to a lawyer in the relevant team to help you, and as many times as you want, and that's all within your membership as well. And other things that are relevant are things like, you know, employment and HR support. So if you are taking on employees, or you want to understand if your policies are all up to date, then that's also something that would be included in the membership. So the special offer that I spoke about earlier, so anyone who watches this webinar is eligible to receive a complimentary consultation to discuss how a membership could help you when you buy a business, and redeem a special offer if you did sign up to the membership. So if you do want to take advantage of this and book any of these strategy sessions, then leave your contact information in the post-webinar survey, or you can email the address that's on the screen, so reply@legalvision.com.au, and just say that you've watched this webinar, and then someone will be in touch to arrange one of those sessions for you. So we really hope that this has been helpful for you. It's been really great to chat to everyone, and yeah, we hope that this has been informative and everyone has a great day.
Yeah, thanks so much everyone for spending some time. See you guys.